It's still in your.
Okay, Mr. Doyle,
Yes, sir.
you want to come forward?
Well, I had talked with the felony prosecutor last week, and there was really not going to be anything that was going to happen today, so I was going to say, can we consider this as to my announcement and get it reset, and I could split?
We're gonna put it on the trial docket because, now these cases, are these cases on the,
These cases are on the arraignment docket currently, Judge. I think we could move it to the announcement if you're willing, but I mean, they're not old at all. They're from March of this year.
okay,
State's picking up.
what docket you want to put it on? Oh, well,
Sir,
okay, he's in, once you get,
he's in custody.
How it's-
He's not here.
He's-
oh, they didn't bring him over?
He's next door. And he's here.
They don't have nothing next door, do they?
252nd.
They have something?
As far as I know, he's not here. He may be in the felony
Okay,
court,
so what,
and
okay, let's,
I don't know.
the-
Or just-
could you check and see if
Yeah.
he's there, if he's fine, if he's there, that's fine. Yeah, okay, y'all can have a seat.
Okay.
Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Case that you have in this court is a criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. Now, the case that you have in here is not only, it is a criminal offense, but it's a misdemeanor offense. And we handle misdemeanors in the county court at Law Number 2. Now, your felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. If a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole, or death by lethal injection. Now, as I mentioned earlier, your case in this court is a misdemeanor case, so you don't have to worry about those type of punishments. Now, your misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. The fine is from $0 to $500. You cannot be given jail time. Now, the Class C misdemeanors do not originate in this court. They do not start in this court. Class C misdemeanors start in the JP court, which is a justice court, or the municipal court, which is the city court. For example, a Class C misdemeanor would be like not wearing your seatbelt, speeding, lot of traffic offenses. Now, if a person is convicted in the JP court or the city court, and then they will appeal their case, in essence, they want their case to come to this court, they get a whole new trial. And then once it comes here, the range of punishment stays the same. It will be minimum $0 to $500 by fine only. Now, if a person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court, the judge that is, can issue what is called a capias pro fine. Capias pro fine means that the judge can issue a warrant for the rest of the person for them to either pay the fine, or if they do not pay the fine, they can sit the fine out in jail. They will receive $100 credit for every day that they sit in jail, and that credit will go toward the payment of the fine and court costs. Now, the next highest misdemeanor is a Class B misdemeanor. Class B misdemeanor range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, a fine from $0 to $2,000. Or a person could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor. And the range of punishment for a Class A misdemeanor is minimum $0 to a maximum of $4,000, or a fine or jail confinement from 0 days to 365 days, which is a year in the county jail, or a person will be given both such confinement and a fine. Now, a person may be eligible for probation. There are 2 types of probation. When I say probation, that means you do not go to jail. You serve your punishment in the community. Now, there are 2 types of probation. One type is called adjudicated probation. Adjudicated probation. The other type of probation is called unadjudicated probation or unadjudicated probation. Now, we normally refer to the adjudicated probation as regular probation. And with the regular probation, a person will have a conviction on their record once they get on probation. However, there's something that is called judicial clemency, where the court or the judge can set aside the conviction. Well, the person will no longer have a conviction on the record, but 3 things has to happen. First, the person has to successfully complete the probation. There cannot be any more time left on the probation. And then the person would have to be successfully discharged off of the probation. If those 3 things happen, then the court can set aside the conviction, and that means that you will no longer have a conviction. Now, however, if the person get a subsequent conviction or another conviction later on, then the case that they received judicial clemency on can be brought back up. It can be revived, resurrected, and it can be used against them. And if they try to get a license with CPS, Child Protective Services, then they could deny giving them a license, or if they have a license, they could suspend or revoke that license. The other type of probation, as I mentioned earlier, is called unadjudicated probation. We normally refer to it as deferred adjudication. Now, with the deferred adjudication, you do not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. A non-disclosure basically means your record is sealed. That is, we cannot tell the general public that you were on deferred adjudication for that case. And now, however, if you fail to complete the deferred adjudication, then the court can revoke your unadjudicated probation and give you a conviction. Okay? But if your probation, as I mentioned earlier, is not revoked, you successfully completed, then you will not have a conviction on your record and you may qualify for non-disclosure. Now, as a defendant in a criminal case, as I mentioned earlier, your case is a criminal case. You have rights. One of the rights that I'm going to talk about is on the clipboard that has been passed out. And that the first right I'm going to talk about is your right to have an attorney. On the first document that is titled Judge's Explanation of Rights to Defendants Without Attorney, on that document it states, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you would like to have an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. Now, if you have enough money to hire an attorney, you'd like to hire your own attorney, then your case will be reset. Reset means that you'll be given another court date from the date to give you time to hire your own attorney. Now, if you do not have enough money to hire an attorney, you would like to have an attorney to represent you, then you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. The financial questionnaire is the document on that clipboard that is titled Jefferson County Affidavit of Indigence. You would have to fill out the first page, and you'll notice at the bottom of the first page, it asks for financial information. If the financial information that is requested on that document does not apply to you, or if you don't, say, have a job, you don't have any, put zero. If you're not receiving any type of governmental benefits, put zero. And then what you're going to do in that category, you're going to add, where it says total, you're just going to add up what's in that category. If everything is zero, your total is going to be zero. All right? And then you can look at the other side of that document at the bottom, where it asks for your expenses. Like if you have to pay rent or mortgage, you will fill that document, you'll fill that out. Or if you have food expenses, all of this is by the month. And then once you finish filling out each line, then you will total it at the bottom. Now, the second page of that document, you would have to fill out the top of the document where it asks for the oath. You'd have to fill out that top portion, and where it says unsworn declaration, near the bottom, you'll fill out that, and at the very bottom, you don't fill that out because that's for the court to fill out or the judge to fill out. Now, once you fill that document out, then the proper person will determine whether or not you meet the eligibility requirements for the appointment of a court-appointed attorney. If you do meet the eligibility requirements, you'll have an attorney appointed today. Next, if you want to represent yourself, that is, if you do not want an attorney to represent you and you would like to represent yourself, then you would have to fill out the document on that clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, only individuals who will be representing themselves would have to read and sign that document. If you are asking for your own court-appointed attorney, or if you are wanting to hire your own attorney, or if you want to have an attorney appointed to represent you, you do not have to read and sign that document. That's only for individuals who will be waiving their right to an attorney and representing themselves. And I'll go over that document with them in a few minutes. Now, at the bottom of the first document, where near the bottom of the first document, where it says judge's explanation of right to defendants without attorney, that first document, it also states that you will have an opportunity to talk to one of the prosecutors, one of the assistant district attorneys who's sitting at the table. You'll only have an opportunity to talk to him if you waive or give up your right to have an attorney. But why? Because you'll be, at that point, acting as your own attorney. So you'll have a right to talk to one of the prosecutors about your case. That's only for individuals who are waiving their right to an attorney and desiring to represent themselves. Now, you should be mindful that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including the loss of significant rights and opportunities relating to military service, housing and public benefits, child custody, immigration status for non-citizens, employment, and possession of a firearm. If you choose to waive or give up your right to have an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of the document that is titled Judge's Explanation of Rights to Defendants Without Attorney, it states in bold letters, defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. Now, this is on the judge's explanation of rights to defendants without an attorney. If your choice is to ask for or request a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if your choice is to waive your right to have an attorney, that means to give up your right to have an attorney to represent you, and you would like to represent yourself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines at the bottom of that document, then you will sign your name on the line that is titled defendant, and you will date it today's date on the line that is titled date, and today's date is September 3rd of 2024. Now, for all individuals who will be waiving their right to an attorney and giving up their right to have an attorney, you'd have to read and sign the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states as follows: I have been advised with the nature and charges against me, and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Voluntarily means that you're doing it of your own free will. No one is forcing you to enter into this waiver. And knowing intelligent means that you know what you're doing. So he says that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 3rd day of September of 2024 by County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed to me free of charge. Understanding my right to have counsel appointed to me free of charge, if I am not financially able to employ counsel, I wish to waive that right. Waive, you mean I wish to give up that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive or I hereby give up my right to counsel. And if that is your choice, then you will sign your name on the line as titled defendant, and you will date it today's date. And today's date is September 3rd of 2024. Now, as a defendant in a criminal case, you not only have a right to have an attorney, but you also have a right to have a trial by jury. When a young lady is sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. And the jurors will listen to all the evidence that is presented by both the state and the defense. They will listen to the arguments that's presented by the state and the defense, and then they will retire to deliberate. And once they finish deliberating, they will decide to find you either not guilty or guilty of your charge. You also have a right to waive or give up your right to have a trial by jury. If you waive or give up your right to have a trial by jury, your case will come before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. We call it a bench trial. It is a trial by judge only, where the judge will be the judge and the jury in the case. The judge will listen to all the evidence, listen to all the arguments, and then the judge will decide to find you not guilty or guilty after applying the facts to the law. You also have a right to waive or give up your right to have a trial by judge. And if you waive your right to have a trial by jury, you waive your right to have a trial by judge, then your case will come before the judge the second way, by way of a plea bargain. It could be by way of what we call an agreed plea bargain or unagreed plea bargain. A plea bargain is an agreement that you work out or your attorney work out with the district attorney to settle your case. We call that a plea bargain. If you are unable to work out a plea bargain, in your case comes before the court. It comes before the court by way of an unagreed plea bargain, which means you and the state have not been able to reach an agreement in your case. And if you and the state have not been able to reach an agreement in your case, then it will come before the judge, and the judge will decide what the punishment would be in your case. Now, if you are able to work out a plea bargain agreement, that will come before the judge. The judge can do one of 2 things. One thing it can do, it can either accept or it can reject your plea bargain agreement. Now, if you and the state have reached a plea bargain agreement to settle your case and it comes before the court and the judge rejects your plea bargain agreement, then you can take your plea back. That simply means that you can withdraw or take your plea back. So for example, let's say the state and you have worked out a plea bargain agreement and the state say, well, judge, we have an agreement, and the agreement is for Mr. John Doe to serve 5 days in jail. And then the court says, well, I reject that agreement. I'm not going to go along with that plea bargain agreement. Then Mr. John Doe can say, well, judge, I take my plea back. In essence, I'm not entering a plea of guilty. I'm not entering a plea of no contest to these charges. In essence, if the judge does not follow an agreed plea bargain, you can withdraw or take it back. Now, if the judge does follow the plea bargain agreement And within 30 days, you decide, you know what, I think I want to appeal this case because I think I've been wrongfully convicted or the court committed an error by convicting me. Now, if you want to appeal after the judge has accepted a plea bargain agreement, you have to get permission from the judge to appeal your case. Okay? Now, if the judge gives you permission, then your case will leave this court and it will go to the Court of Appeals. It will go upstairs to the Ninth Court of Appeals. And the judges up there will review the case. They can do one or two things. They can either grant your appeal or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. Or if they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review. And what that means is, pro se means that you're representing yourself. You do not have a lawyer representing you. And you're petitioning the Texas Court of Appeal to review your case, to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted or this court committed an error by convicting you. They can do one or two things. They can either grant your petition or deny your petition. If they grant your petition, they can simply find you not guilty, or they can send the case back to the Ninth Court of Appeal with orders, or they can send the case back down to this court with orders, give you a new trial or whatever. And if they deny your pro se petition, then at that point, your conviction will stand. All right. Now, we talked about your right to have an attorney. We talked about your right to have a jury trial, your right to have a bench trial, a judge only, your right to enter into an unagreed plea bargain agreement or an agreed plea bargain agreement. Now, you also have a right to have witnesses that come to court. Witnesses, what they do is testify. They can witnesses, they sit in that chair right there where the microphone is. We call that the witness stand. They can testify for you or against you. If you're representing yourself, you can ask them questions. Or if you have an attorney representing you, your attorney can ask them questions. We call that either direct examination or cross-examination. Now, you can also waive or give up your right to have witnesses, which means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have what is called a Fifth Amendment right against self-incrimination. I know if we watch these television shows, you hear somebody say, I take the fifth. And what that means is I'm not saying nothing. In essence, you have a right based on the Fifth Amendment of the United States Constitution not to testify against yourself. We call that the Fifth Amendment right against self-incrimination. Now, if you exercise your Fifth Amendment right against self-incrimination, the state, the prosecutor, the government, the DA's office, they cannot call you as a witness in your case. Right? Now, you can waive or give up your Fifth Amendment right against self-incrimination. If you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be testifying in your case. Now, you also have a right to have what we call discovery. Discovery means that you have a right to see what's in or to have access to the evidence that the state has against you. You have a right to see your statement, witness statements, right to see lab reports, police reports. You have a right to see photos, video recordings, listen to audio recordings. You have a right to see whatever instruments that they may be using or whatever type of documents that they have, in the case you have a right to have access to it. Okay. Now, you also have a right to waive or give up the right to have discovery. And as I mentioned, discovery is your right to see the evidence that the state has against you. And if you waive or give up your right to discovery, then you will not be having access to the discovery. Now, as a defendant in a criminal case, well, everyone that's here on docket, you're here in court today, you have been arrested, you've been booked in jail, and you're out of jail either on a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or you are out of jail on what we call a PR or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear here in court. Now, every day that you have spent in jail, that jail time can be used as credit towards your punishment. And when I say every day, I'm talking about not every 24 hours. I'm talking about every different day. So for example, let's say you were booked in jail at 11:59 p.m. and then you booked out 2 minutes later at 12:01 a.m. That's 2 different days. So you have you've been in 2 minutes, but you get 2 days credit. Okay? It's it's the different days. And so every day that you spent in jail, it could be used as credit towards your punishment. So for example, let's say you're in the state that worked out a plea bargain agreement. Let's say, for example, you served 5 days in jail. The state is offering you to serve 5 days in jail. You will not have to serve any more time in jail because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail and you spent 5 days in jail, that only means that you only have to spend 2 days in jail because you already have 5. You take 5 from the 7, that leaves 2. Now, every day that you spent in jail, you also get credit toward your fine and court costs. So every day that you spend in jail, you receive $100 per day that will go toward your fine and court costs. So if the state is you spent 5 days in jail, that's $500. If the state is offering you fine and court costs of $500, you don't have to pay nothing. Why? Because you already have $500 credit that can go toward that, and so it'll be what we call tax and retire. Now, if the state is offering fine and court costs of $700, you spend 5 days in jail, which is $500. That means you only have to pay $200 because we'll take the 5 from the 7, and that leaves 2. Now, if you are ordered to pay fine and court costs, let's say in that same scenario, you owe $200, you'll be required to pay it on the day that you dispose of your case. Now, if you can't pay it, no problem, because we can put you on what is called a payment plan. You can pay monthly installments until the balance is paid off. Now, even if you have a job, don't have a job and you can't pay it off, no problem, because we can convert that $200 fine and court cost balance to community service. And you receive $12.50 for every hour of community service that you perform. That will be credited toward your fine and court costs. So theoretically, or technically, if you work 8 hours community service, that's $100. So in our scenario, you got $200, you work 16 hours of community service at a nonprofit organization, you paid off the $200 that you owe. All right. Now, Jefferson County has a program that is called pretrial diversion. If you've never been in trouble before, first time getting into trouble, with the pretrial diversion program, they will dismiss your case. And if you successfully complete the program, you can get it wiped off your record. We call it expunge. You can get expunged erased or deleted from your criminal record. And the way it works is you have to, one, have to be your first time getting into trouble. Two, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. And three, you have to have an attorney to assist you at filling out and submitting the application to the district attorney's office. As I mentioned earlier, if you get into the program, your case is dismissed. You complete the program, you can get it erased or deleted from your record. Now, Jefferson County District Attorney's Office also has another program that is called Veterans Court. Veterans Court is for veterans only. If you are a veteran of any one of the branches of the United States military, with that program, you get into the program, and once you complete the program, then they will dismiss the case, and you can get what is called a non-disclosure. As I mentioned to you earlier, a non-disclosure is where your record is sealed to the general public. The general public cannot have access, and notice that I'm using the term general public. That's because the government can have access, but most of the public is general public. Most of the jobs that you will be applying for is general public, and so they cannot have access to that. Okay, that's what a non-disclosure does. Now, this court, Jefferson County Court at Law Number 2, has a program that I started within the first 3 months or the first 100 days of taking office in March of 2017. The program is called the CSI program. CSI stands for Community Safety Initiative. It is a program designed to address the issue of recidivism. Recidivism basically means when people are committing crimes over and over. And so how do we stop that? How do we prevent that? How do we address it? Well, we address it through the CSI program or the Community Safety Initiative. And we address it with partnerships that we have in the community. One of the partnerships that we have is with Spindletop Center. And we have folks here from the Spindletop Center who's going to come in a few minutes and tell you more about the program. Spindletop is our local mental health center in our Southeast Texas region. Spindletop has the ability to address your mental health needs. Now, in order to participate in the program, you do not have to be incompetent or insane. You can merely suffer from anxiety, depression, or any other host of mental illnesses, and they have the knowledge and expertise to address your mental health needs. Now, what Spindletop will do, they can do a private interview either here in our jury room, or they can do it at their facilities, or you might prefer to do it over the telephone, whichever is convenient for you. They also have the ability to do assessments. They can develop treatment plans for outpatient and inpatient treatment as well. Now, Spindletop also has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. It's an acronym, ATAR, Addiction, Treatment, and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OZAR. OZAR, the acronym is OSAR, and it stands for Outreach, Screening, Assessment, and Referral. All the OZAR and the ATAR program are both drug and recovery programs to address issues that individuals have with alcohol and or drugs. They will do a private screening, an assessment, and they can refer you to either outpatient or inpatient treatment to address your drug or alcohol issues. If you're unemployed or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called the CICE program. CICE is the acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, they will assist you at getting a job. In essence, they will help you to get placed on a job in the area that you're trained in. Now, the beauty about that program is that there are individuals who may get training somewhere else, or they apply for a job and they can't get in, maybe because of their criminal record. But when they go through the CICE program, apply for that same job with the same, they get in because you're getting in through the CICE program. The other thing is, if you have not graduated from high school, or you do not have your GED, the CICE program has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned are free. It does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes because they have too much to lose. And so I like to say, when you come to County Court at Law Number 2 of Jefferson County, Texas, we do not have court as usual, we have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that come before the court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know and we'll be happy to direct you to the people that you need to talk to get into this program. Now, the other beauty about this program is that all of these programs that I just mentioned in the CSI program can be used as community service. So, for example, let's say you were unable to pay your fine. And so we converted the fine to community service. And let's say you decide, well, I want to get that job training at CICE, or I want to address some mental health issues that I might have. I want to address some alcohol or drug issues that I may have. Every hour that you're in any one of those programs, $12.50 will be going towards community service, and 1 hour will be going toward the program. So I like to tell people this all the time, that you're not killing two birds with one stone, you're killing three birds with one stone. You're in the program, you get community service, and you're paying your fine and court costs by doing one thing. Okay, so if you're interested in the program, just let us know, and we'll be happy to give you brochures and direct you to people that you need to talk to get in the program. Now, at this time, as I mentioned earlier, we have some folks from Spindletop. They're going to come now. We have Chris, and we have Deputy Hinton, a mental health deputy, who's going to come, and they're going to tell you more about the program that they have to offer at Spindletop. Deputy Hinton and Chris.
Thank you, Your Honor. Good morning. My name is Steve, Deputy on the State Commission here with the Sheriff's Department. I'm going to Chris. Now, Chris is a qualified mental health professional. The reason we are both here this morning in this courtroom is the judge cares about every single person who comes to the bench. What the judge has found, specifically proves those with legal issues not only have mental health needs, such as use disorders, or sometimes the lack of community resources to help you with your particular situation.
This has a fair amount on it. It's just allergy, I promise, so I apologize if anyone can't hear me. If any other questions, please just let me know. So, I know the judge mentioned inpatient, outpatient, that's just resources, right? We can get you information if you need any form. We're not gonna be able to send anybody to you. Don't worry about that. Now, the judge mentions whether he talks about mental health concerns, that's anxiety, that's depression, that's the things that we all deal with at some point in our life. Obviously, there's other issues that we can deal with, or that our loved ones deal with. And we can still work with them. It's just that this is not necessarily a therapeutic environment. Where a lot of times, something things kind of flare up. Yeah, there's a lot of really great community resources that are well funded, but they're not well advertised. And sometimes just finding a name for one to be like up with their boots. And if you're already juggling everything else, and you know, it's just one extra thing, even if you help, it's just an extra thing. So it's kind of a weekend. We can be there to help you find what you need, and you get there to talk to you. Sometimes we're missing resources, just support. We always, even if you have supportive people around you, sometimes you need somebody that's disconnected from your events and doctors. And we can help with that too. It's just making sure that you have access to what you need.
Maybe this is your first time to be in court, it could be your fifth time to be in court, there's still hope. And what we're offering you today has the ability to change your life. We're gonna need something from you, we're gonna need you to share that need with us, so we can best see how to advocate and help you. And Chris will explain exactly how you can do that very privately.
When everybody came in, I did meet everybody, all received one of these, right? If I missed anybody, please let me know. This is form, like a baseline of consent account. The reason it's made this way, so you have any information you put on the feed, if you're typed under state law, it's not gonna go anywhere else, the only person who's gonna see it is me. The only thing that's allowed me to do is reach out to you in a manner of your choosing, to follow up and to see how things went here, and also to see if there's anything I can help with, and to make sure that you have contacts for any point you need someone to follow up. One of the big things is making sure you have access, because I know this is, again, not a therapeutic environment, right? This is not a place where you should learn about the things that you can get connected to in the community. You should have heard about these things in the beforehand, and unfortunately, a lot of times, no one does. So if there's something we can do to help, we want to. That's the big thing about it, that we can use them right there, is to make sure that it is out. And I know that there's a lot of people outside of the call that probably are not in this room right now, that's nothing against us, life happens, right? But you all make something to be here today. I know it's the only place anybody wants to be, or know that anybody wants to find themselves in, or one that we're really prepared for. But we all should. And so we're all on, make sure that we can provide into the one side and make this feel more productive, to make your life in general outside of it easier. So if there's something we can help with, if there's something you need, or if you just want to help, please let us know, okay?
I also have this business card that I want to give everybody today. It tells you, has a 1-800 number on there. If you ever find yourself in a safe place, you can call that number and get help immediately.
Now, that's important. It also has the office number for Small Talk. The resources we connect to aren't just through Small Talk, we're just housed through them. But that card is important because it's the first resource we can give you. That number is active almost statewide. We say almost because we all know there's many places in Texas where you can't get a cell, you can't get a signal no matter what area you have. But if you can get a signal, you can call. They're active 24/7. You call them 6 a.m. this morning, you need to talk to start coming. And repeat it. There's plenty of other resources we have access to, we can get you as well, but that's the first one, and that's when we can get you to get in the court. Sure. If it's between the hours of 8 and 5, and you wanna talk to one of us instead. But this is something that you can reach out to at any point, no matter what's going on. When it calls them out, we have to, understand, so one of the big things about it is actually statewide, right? It doesn't matter if you're coming up to the county, you understand all of you coming up in court here, from all over, right? Where people are coming from. It just matters that you're not fine. But if you're looking at you fine, we'll have to look. It doesn't matter if you come from the county, we're not limited to the location. Things like that, you got it. It also doesn't matter if you're here for yourself, you're here for somebody you care about, or to maybe get information for somebody you don't care about outside of you. If you shut up, you want to do our best to help you whenever we can. So something of us is, it's not just for someone who's a defendant here. And it's not just for, if you need information for you. We function as your phone, that's the only way we can function. Because it's the only way we not much we can. Yeah, well, I know I'm probably, I'm sorry, guys, but I appreciate it.
But just shortly, court is going to go into recess. When it does, we'll be okay to visit with you. I'll be handing this out for everyone as well. We'll be picking up those documents. We'll be able to answer any questions you may have at that point as well.
One of the other things is, I'll be in the jury box over there. I understand, and again, this is not a therapeutic environment, right? If at any point anybody starts to feel symptoms of anxiety or any sense of panic, are we watching over there? If you put your hand up, or if you touch your ear, touch your nose, and make eye contact with you, I will come over and sit with you, and we will find a moment to let you breathe, okay? We're all here the best. So, again, let's hear it out. Let us know what you want.
Thank you, Your Honor.
Okay, thank you, Deputy Head Chris. Now, ladies and gentlemen, the paperwork that's on the clipboard, that we went over earlier, make sure that it's filled out. If you need help with filling out that paperwork, we have our court personnel who's here, who's willing and able to assist you with filling out the paperwork. Now, once the paperwork is filled out, we're going to pick the paperwork up. We're gonna go through that paperwork, and then we're going to call you before the bench one at a time. And then once we called you here, we'll refer you to the court coordinator. Some people who is hiring their own attorney, their cases will be reset. People who will have court-appointed attorneys, your attorney will be appointed here today. And the others who will be representing themselves, cases will be disposed of today. So now this is gonna take us a few minutes to go through, to pick up the paperwork and to go through and evaluate the paperwork. Now, if you need to use the restroom, there are two restrooms right outside the door in the hall. We have the men's restroom in front of County Court at Law number 3. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. Okay. Now, if you need help with your paperwork, just simply raise your hand and we'll have someone, they'll be out in the gallery to assist you with filling the paperwork out. So at this time, the court will be in recess. Mr. Lodge,
Yes.
this is cause number 24 CCCR 1968. And Miss Delodge, you here on Kayla Marche Davis?
That's correct.
Okay. And my understanding that the felony case was reset.
Correct. Her felony attorney, Mr. Smith, is sick today, so they reset her case.
Okay. Now, does this case rise out of the same criminal episode?
How much is it? I think so, but I don't want to say that.
I don't want to speak off the top of my head. Good.
I see you just appointed on this last month.
Yes, sir, it's a relatively new one for me.
We could keep this one we'll keep it with the felony.
It is not of the same date.
Okay, well, we're just gonna keep the announcements, we'll keep that. And so you're gonna have to announce, I guess, when you come back on that date,
Yes, sir.
okay?
Yes,
We're gonna reset, Davis on the same date with the felony.
And I don't know that they've already got the reset date.
They do.
They do.
Yeah.
Then.
Here you go.
Okay. All right,
Thank you, Judge.
you are.
That is my only case.
Yes, you're free to go. You have a blessed day. Jefferson County Court at Law number 2 is back in session with the arraignment docket. When I call your name, please come forward before the bench. First case is cause number 23CCCR of 23. What else? 2384. Case to style the state of Texas versus Merritt Lance Cox. Mr. Cox, your full name is Merritt Lance Cox. Mr. Cox, would you please raise your right hand? Mr. Cox, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Cox, you may put your hand down. How are you doing, Mr. Cox?
Good.
That's good. Mr. Cox, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Cox, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
I have. Now, Mr. Cox, before you signed and initialed this document, did you read the document?
I'll glance over
Okay, did you understand what you read?
it. I thought so.
Okay, and is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Mr. Cox, I read your answers. Your case is gonna be reset by our court coordinator to give you time to hire your own attorney. But before she gives you the reset, the bailiff is going to give you a document that is titled Standard Bond Conditions in County Court at Law number 2. And I'm going to go over this document with you. Do you see that document?
Yes, sir.
Okay, Mr. Cox. It states Standard Bond Conditions in County Court at Law number 2. Following return of a permanent information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. You understand that condition?
Yes, sir.
Now, condition number 4 does not apply because that only applies in the DWI case. However, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by Section 107 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Sure.
Now, Mr. Cox, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay. Now, Mr. Cox, as I mentioned earlier, your case will reset. Please stand in front of the court coordinator. She'll give you a reset. Once you get the reset, you're free to go, and you have a blessed day.
Thank you.
You're welcome.
Very good.
Next case is clause number M329225. Case is style the state of Texas versus Leonard James Collins. Mr. Collins, your full name is Leonard James Collins.
Yes, sir.
Mr. Collins, would you please raise your right hand? Mr. Collins, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Collins, you may put your hand down. How are you doing, Mr. Collins? You're doing pretty good. That's good. Now, Mr. Collins, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Collins, do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to reset your case to hire your own attorney?
Yes, sir.
Mr. Collins, before you signed any initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Mr. Collins, your case is going to be reset by our court coordinator. Once your case is reset, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall. Next case is cause number 24CCC 1606. Case is style of state of Texas versus Felicia Ann Harris. Ms. Harris, your full name is Felicia Ann Harris?
Yes, sir.
Ms. Harris, would you please raise your right hand? Ms. Harris, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Harris, you may put your hand down. How are you doing, Ms. Harris?
Pretty good.
That's good. Ms. Harris, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you'd like to have your case reset to hire your own attorney?
Yes, sir.
Ms. Harris, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Ms. Harris, your case is going to be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to reset your case. Please have a seat in that third chair, and once you get your case reset, you're free to go and you have a blessed day. Abraham Zavala, cause number 24CCCR 1648.
Collins?
Mr. Zavala, your full name is Abraham Zavala? Mr. Zavala, would you please raise your right hand? Mr. Zavala, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Zavala, you may put your hand down. How are you doing, Mr. Zavala? I'm doing fine, thanks for asking. Now, Mr. Zavala, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Or these your initials on the line that state you have already hired an attorney, and the name of the attorney is Keith B. French?
Yes, sir.
Now, Mr. Zavala, before you signed and initialed this document, did you read the document?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Okay. Mr. Zavala, your case is going to be reset to give your attorney, Mr. French, an opportunity to submit a letter of representation. That letter indicates that he has been hired by you. And once we get that letter, the case probably will be reset to another court date. But before we get the letter, we're going to give you a court date. Okay? So once you get the court date from our court coordinator, you'll be free to go on your best day. Please have a seat in that first chair on the wall. Next two cases are cause numbers 24 CCCR 0548 and cause number 24 CCCR 0549. Both cases are styled the state of Texas versus Raphael Tillman. Mr. Tillman, your full name is Raphael Tillman. Tillman, would you please raise your right hand? Tillman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Tillman, you may put your hand down. How are you doing, Mr. Tillman?
Fine.
I'm doing fine, thanks for asking. Mr. Tillman, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Tillman, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Mr. Tillman, do you recognize this document?
Yes, sir.
On page 2 of this document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Mr. Tillman, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? So, Mr. Tillman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that would be appointed to represent you in this case, or in these cases rather, is Tom Burbank. Attorney Burbank will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Next case is cause number 24 CCCR 1466. Case is styled State of Texas versus Cassandra Owens. Ms. Owens, your full name is Cassandra Owens.
Cassandra Denise Owens.
Okay.
Yes, sir.
Ms. Owens, would you please raise your right hand?
Yes, sir.
Ms. Owens, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Owens, you may put your hand down. How are you doing, Ms. Owens?
I'm blessed, sir. How are you?
I'm blessed as well. Thanks for asking. Now, Ms. Owens, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir. I do.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir, it is.
Ms. Owens, before you signed and initialed these documents that I just showed you, did you read the document?
Yes, I did.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Owens, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney.
Yes, sir.
And the attorney that will be appointed to represent you in this case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go.
Okay.
And you have a blessed day. Please have a seat on that third chair on the wall.
Oh, yes, sir.
Un abogado y le va a apuntar el abogado Charlie Rojas para que lo represente. He said thank you.
Okay, now, let me do this here. Oh. Show him these documents. And you could show him these, ask him if he recognized.
¿Reconoces tus documentos? Yes.
Okay. Now, one document is judge's explanation of rights to defendants without attorney, and the other one is the affidavit. Now, Ms. Renteria, you the interpreter, ask him if, well, Ms. Renteria, you went over these documents with him, is that correct?
Yes, sir, I did.
So we're gonna ask Mr. Zavala if he understood everything that you went over with him.
¿Sí entendió esos documentos que que llenamos?
Sí, la pregunta que me
Yes.
hizo.
Okay. All right. Now, the bailiff has just handed him a document that is titled Standard Bond Conditions in County Court at Law number 2, and I think she gave you one too?
Oh, okay. Yeah.
Okay. And basically, I can read it, and then if you can interpret, I can read the first paragraph. Well, the first sentence, it says, following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release for any defendant named herein are ordered subject to the additional condition. Could you read that portion to her?
Esta forma que el juez le leyó son las condiciones de su fianza, el cual usted ha ejecutado para la orden de estos casos.
Okay, let me do this here. Let me swear in.
Alza su mano derecha.
Okay, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Usted jura decir la verdad, nada más que la verdad, so que lo ayude Dios. Yes.
Okay, you can put your hand down. Now, the first bond condition is the defendant shall commit no offense against the laws of this state, any other state, or of the United States. You can ask me if you understand it. once you-
Si entiende que no puede cometer otra ofensa en este estado o otro estado en los Estados Unidos. Yes.
Okay. Number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and a test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that?
También quiere saber si entiende que durante el tiempo que está en fianza puede ser sometido a un examen de drogas o algo.
Sí, ya no uso nada.
Yes, he's not under those influences.
Okay, and number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim.
Nomás está diciendo que si tiene una víctima en este caso, no puede estar alrededor de esa víctima. Okay.
I understood that, okay. Now, number 4 does not apply, but number 5 on the next page does apply. And number 5 states, the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07, the penal code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. And ask him, does he understand that?
El punto 5 es el punto que le corresponde más a usted diciendo que no puede cargar o posesionar una arma. Entonces, la única manera que puede poseer una arma es si usted es un oficial. En cuanto que la tiene que usar por medio de su trabajo. Y pues sí. Pero no posee una arma usted. Is that okay?
Yeah, okay. Now, tell him if he violate any one of these bond conditions, a warrant could be issued for his arrest, he'll be arrested and placed in the Jefferson County Jail.
Si usted viola alguna condición de su fianza con estos puntos que le explicamos, puede ser arrestado y le da de alta su fianza. Si usted posee una arma o en otros que ya le explicamos que no puede cometer otra ofensa en este estado o en otro estado. Okay.
Okay. Tell him his case is gonna be reset by the court coordinator once he get it reset.
Le vamos a dar otra fecha para que venga a corte.
He'll be free to go. And again, his attorney is Charlie Rojas.
Usted se puede ir ya que le dé la información, su abogado va a hacer parte de eso.
Mr. Rojas is gonna contact him and he'll be given information to contact Mr. Rojas.
Is this his document, Judge?
That's his
Okay,
copy.
eso es usted, su copia.
Ok, muchas gracias.
Ajá. Y vamos a pasar.
Okay, thank you, Ms. Renteria.
You're welcome. Y ella le va a dar la fecha cuando va a venir a corte con su abogado, Charlie Rocha.
Voy a hablar con la abogada.
Ujú.
Does I have something from
Jefferson County Court at Law number 2 is back in session. Next case is cause number 24 CCCR 1324. Case is styled State of Texas versus Michaela Kelly's Cole. Michaela Cole was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Michaela Cole at the courthouse door. Michaela Cole did not answer. Michaela Cole has not appeared in court since the court has been in session. The time now is 11:21 a.m. on today's date of September 3rd, 2024. Ms. Bailiff, would you please call the name of Michaela Cole at the courthouse door?
Michaela Cole. Michaela Cole. The response on it.
Michaela Cole's name was just called again at the courthouse door. Michaela Cole did not answer. A reasonable time has appeared to give Ms. Cole an opportunity to appear in court. She has not appeared in court. State, do you have a motion? That motion will be granted. Michaela Cole's bond will be forfeited and a warrant shall be issued for her arrest. Next case is cause number 23 CCCR 2584. Case is styled the State of Texas versus Gemma A. DeCloudy. Ms. DeCloudy was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Gemma A. DeCloudy at the courthouse door. Ms. DeCloudy did not answer. The time now is 11:23 a.m. on today's date of September 3rd, 2024. Ms. Bailiff, could you please call the name of Gemma DeCloudy at the courthouse door?
Gemma DeCloudy.
Gemma DeCloudy's name was just called again at the courthouse door. Gemma DeCloudy did not answer. Time has been given to give Ms. DeCloudy an opportunity to appear in court. Gemma DeCloudy has not appeared. State, do you have a motion?
Statements for bond forfeiture.
That motion will be granted. Gemma DeCloudy bond will be forfeited and a warrant shall be issued for Gemma DeCloudy's arrest in cause number 23 CCCR 2584. Next case is cause number 24 CCCR 0914. Case style of State of Texas versus Martavian DeMarcus Evans. Martavian DeMarcus Evans was scheduled to be in court this morning at 9 a.m. and at or about 9 a.m. The court's bailiff called the name of Martavian Evans at the courthouse door. Martavian Evans did not answer. Martavian Evans has not appeared in court since the court has been in session. The time now is 11:24 a.m. on today's date of September 3rd of 2024. Ms. Bailiff, would you please call the name of Martavian Evans at the courthouse door?
Martavian Evans. Martavian Evans. Number 5.
Martavian Evans' name was just called again at the courthouse door. Martavian Evans did not answer. A reasonable time has passed to give Martavian Evans an opportunity to appear in court. Is not appearing in court. State, do we have a motion?
Statements for bond forfeiture.
That motion will be granted. Martavian Evans' bond will be forfeited and a warrant should be issued for his arrest in cause number 24 CCCR 0914. Next case is cause number 24 CCCR 0154. Case is style of State of Texas versus Byron Keith McCartney. Byron McCartney was scheduled to be in court at 9 a.m. at or about 9 a.m. Court bailiff called the name of Byron McCartney at the courthouse door. Byron McCartney did not answer. Byron McCarthy has not appeared in court since the court has been in session. The time now is 11:25 a.m. on today's date, September 3rd, 2024. Ms. Bailiff, would you please call the name of Byron McCartney at the courthouse door?
Yes, sir. Byron McCartney. Byron McCartney. No response, Your Honor.
Byron McCartney's name was just called again at the courthouse door. Byron McCartney did not answer. A reasonable time has passed to give Mr. McCartney an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Statements for bond forfeiture.
That motion will be granted. Byron McCarthy's bond will be forfeited, and a warrant shall be issued for his arrest in cause number 24 CCCR 0154. Next case is cause number 23 CCCR 2214. Case is styled the state of Texas versus Irvin Ernesto Ubieta Enriquez. Mr. Irvin Ubieta Enriquez was scheduled to be in court at 9 a.m. on today's date of September 3rd of 2024. At about 9 a.m., the court's bailiff called the name of Irvin Ubieta Enriquez at the courthouse door, and Mr. Ubieta Enriquez did not answer. He has not appeared in court since the court has been in session. The time now is 11:28 a.m. on today's date of September 3rd of 2024. Ms. Bailiff, would you please call the name of Irvin Ubieta Enriquez at the courthouse door?
No response, Your Honor.
Irvin Ubieta Enriquez's name was just called at the courthouse door. Mr. Ubieta Enriquez did not answer. Reasonable time has passed to give Mr. Ubieta Enriquez an opportunity to appear in court. He is not appearing in court. State, do you have a motion?
Statements for bond forfeiture.
That motion will be granted. Irvin Ubieta Enriquez bond will be forfeited. A warrant should be issued for his arrest in cause number 23 CCCR 2214. Next case is cause number 24 CCCR 0414. Case is styled the state of Texas versus Raya Lene Young. Raya Lene Young was scheduled to be in court at 9 a.m. At about 9 a.m., Raya Lene Young name was called at the courthouse door by the court's bailiff. Raya Young did not answer. Raya Young has not appeared in court since the court has been in session. The time now is 11:29 a.m. on today's date of September 3rd of 2024. Ms. Bailiff, would you please call the name of Raya Young at the courthouse door?
Sir. Raya Young. Raya Young. No response, Your Honor.
Raya Young name was just called at the courthouse door by the court's bailiff. Raya Young did not answer. A reasonable time has passed to give Ms. Young an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
Statements for bond forfeiture.
That motion will be granted. Raya Young's bond will be forfeited, and a warrant should be issued for arrest in cause number 24 CCCR 0414. And this will conclude the calling of the court's arraignment docket on today's date of September 3rd, 2024, in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day, and prosecutors, you are excused.
Thank you, Judge.
Okay.